Hi everybody. Today we'll um, show you the article "Rights of Nature, Rights of Animals." And Judy Mori will present to you. Okay, I'd like to introduce you, Judy Mora. Good luck, Judy.
Okay, so good morning, everyone. This essay is called Rights of Nature and Rights of Animals. It was written by Kristen Stilt. And the author basically shows how developments and achievements in the field of environmental rights and rights to nature can be instructive to the cause of animal protection and animal rights. So basically, the author does this connection between animal law and environmental law. And he says that the both fields observes that animals, human and non-human, exist in the environment. But the things that environmental law is a little more concerned with animals at the level of species. So the way they are endangered or threatened. But in another way, the animal law is more concerned with all animals in general, regardless their particular characteristics. She talks about the case of the wild horses in the western of the USA. Um, and she makes this comparison between the environmentalist view and the animalist view. So the case of the wild horse in the USA is that for some of them, for some of the Americans, they are seen as feral beasts that can damage the fragile ecosystem and compete with wildlife. But in another term, the animalists see this wild horse as life, as animal life, and they should be protected. So there is this difference between the environmentalist view and the animalist view. She continues to talk about how environmental law is different from animal law. So she says that environmental law is typically anthropocentric, as most constitutions address the human right to a healthy environment. So they have this view that environment is concerned to human well-being. And of course, nowadays, there is this idea of rights of nature. We have already some constitutions that writes about this new trend, writing about this ecocentric, biocentric view, as for example, the Constitution of Ecuador. But normally, typically, the current constitutions, they have this anthropocentric view. So animal law is a more recent phenomenon. And some constitutions just use terms as welfare of animals, dignity of animals, animal protection, compassion toward animals, and animal cruelty to assign constitutional significance to the experience of individual non-human animals. But none of them use the term rights. So, how this view about the human right to a healthy environment can be applied to animal protection? The author speaks about how the rights of nature can be applied to rights of animals. She starts to say that the rights of nature point of view have two sources. First, that current environmental law has failed to address the global ecological crisis, and that indigenous traditions and jurisprudence that treats humans as part of nature rather than distinct from it have long provided a right of nature framework. So she does this analogy with the animal context. So as an analogous formulation, would be that a human right to animal protection and a right of humans to have all animals adequately protected. So a human right to animal protection could offer the possibility of a more protection than currently exists under animal welfare laws. So if we use this anthropocentric approach to animal protection, it would be more acceptable than the animal rights-based approach. So she continues to do this. Sorry, it was my dog. So she continues to do this comparison between rights of nature and rights of animals, and saying that this ecocentric or biocentric approach from rights of nature may be promising for development of legally recognized animal rights. So why is this? Because animals are part of nature. So if nature has rights, and if nature includes animals, then rights-based claims could be made on behalf of animals. She talks about the example of Ecuador, the Constitution of Ecuador, the Constitution of Bolivia, and also she says the case of the wild parrot, which was judged by the Superior Court of Justice in Brazil in 2008, on which an individual had kept a single wild animal, which was a blue-fronted parrot, and he kept in custody for more than 2 decades and in inadequate living conditions. So the Superior Court on that time, they said that the treatment of animals must be based no longer on human dignity or human compassion, but on the very dignity inherent in the existence of non-human animals. She continues to talk about this idea of non-human rights, saying that how can corporations and other non-human entities be legal persons and have rights, but entities such as rivers or ecosystems haven't been extended the same recognition by the legal system worldwide. She talks about the exceptions from this point of view, which are from the jurisdictions of Bangladesh, Colombia, Ecuador, India, New Zealand, and the United States, that already recognized that rivers can be treated as legal persons in these jurisdictions. She says about the Atrato River case in Colombia, which was being polluted and degraded by industrial and legal mining. And she says that the plaintiffs showed that the Atrato banks were the ancestral home to Afro-Colombia and indigenous communities, and also that the river provided a subsistence means of living based on agriculture, hunting, fishing, and artisanal mining. So they asked to the court to protect their fundamental rights to life, health, water, food security, health environment, and the culture and territory of their ethnic communities. The court basically accepted their complaint, and also did not limit itself to a consideration of these anthropocentric rights, but they also said that the importance of nature was established as entities who deserves protection in and of themselves. There was also this Turag River case in Bangladesh. So there was an encroachment on the Turag River due to river grabbers, pollutants, and encroachers wailed off land in the river and deployed bulldozers and excavators to fill their newly claimed territory. So basically, they were creating land on the river and claim it their territory as theirs. So the case on this case, the Turag River was at the center of it, and with people speaking in terms of the Turag becoming a dead river facing extinction if this activity wasn't stopped. So the court also acknowledged that the occupation and pollution had caused a major shortage of potable water for which people are constantly facing health risks. So finally, the court declared that the Turag and all rivers in the country are legal persons and ordered the removal of all unlawful pollution and construction. So she continued to talk about other cases, as for example, the deforestation case in Brazil, which also the Superior Court of Justice decided that to restore the damage caused to the environment, a defendant may also be required to pay monetary damage or poor ecological damage. Applied to the animal context, sorry for the contexto, which was like an error. Applied to the animal context, it could stand for the principle that wrongful treatment of an animal could require also the payment of compensation without having to showing any particular physical harm. So she concludes that rights of nature approaches are instructive to the cause of animal rights intellectually and practically. They don't offer a model to be copied, but instead call for careful study of the parallels and points of disconnection of the commonalities and the conflicts with the potential for significant results.
Okay, Judy, thank you so much. I will finish the broadcast. Okay, let's talk. Let's start.